skipping a big step. Yearsley was never an immunity case, not because it was after trial, but because the issue in Yearsley was who was responsible for the taking. And what we said is the agent was not responsible, it was the government. He was acting at the government's direction. The government can take, so sue the government, all right? That's what we said in Yearsley. The fact that we've inartfully called it an immunity, it's really a question of relief from liability. That's all Yearsley was about, was saying, you, the agent, is not liable, the principal is liable. So I don't know why the reliance on, or even claiming this is an immunity defense. But putting that aside, you're taking a step further. You're taking what the Yearsley court said, it was, was what the government did lawful? Congress can pass a law that permits the government to send texts to 16-year-olds. But if it passes a law that says our military, no one can send a text, including our military, then I don't think that the military giving an order to its contractor to do it gives the contractor immunity. It may give it a defense to liability. I'm not sure what that defense would be, because Yearsley said you have to be following a lawful government order. But this is circular to me.
I think what Your Honor is asking is, what if Congress passed something that was outside of its constitutional authority, like no one shall text anybody? If that was the instruction, say to a satellite operator that was a government contractor, just jam all the text, don't let people communicate or speak with each other, there would be a very good argument that that is outside of Congress's authority to authorize because it can't shut down speech. Great.
And we're back to Yearsley. Can the contractor,
great. So
who should be responsible for that loss? But that's still a liability question, not an immunity.
No, it's not. I mean, so throughout the history of this body of law, the court has consistently emphasized that it's avoidance of suit, that it is an immunity from suit. And that is different, of course, than just avoiding liability. Now, the other side cites a number of times where the word liability appears in this court and other courts' decisions. So, for example, the Newman case, which is the New York subway case, and Sally Oat are two that we talk about in the papers. They excerpt the word liability, but liability is avoided by both a defense and an immunity, so that doesn't tell you enough. But if you look deeper at those cases, you can see, and I think it's page 28 of the reply brief, you can see why the reasoning is, in Newman, for example, the court says, because the contractor stands in the shoes of the government, it has all of the immunities that come with being the government's, doing the government's work. And in fact, Yearsley and Brady say that. They cite United States versus Lina to say the action of the contractor is the action of the government.
Thank you, counsel.